guys.
All right.
Thank you so much for coming to our event. Stephen and Michael will be talking right now. And if you guys have any questions after, we'll do a little Q&A.
Yeah, thanks again for coming. There's going to be not just Q&A, there's going to be a quiz. No, there's no quiz. So we just wanted to bring you guys together, mostly for networking, but then we also try to, at TaxWise, we try to bring some value by bringing in subject matter experts and talking about what they're a subject matter expert on. And then I dabble a little bit on asking the questions. So we've got about 15 or 20 minutes. We're going to talk about estate planning with real estate. And but think of this as less, it's not a lecture, it's an open table. So as we talk about things, pepper questions, see if you can stump Michael. And if you do, you don't have to take the quiz. So, all right. So first thing we think about with real estate and estate planning, we'll start with the foundation. And so let's think about the foundation, right? That's good, right? So let's think about how property is titled. So why does that matter so much? Titling.
Well, titling property matters because when you kind of look at the whole big picture, we're looking at estate planning and real estate. What do they have in common? And it's the word estate clearly. And estate basically means property or ownership of property. And when I think of it, when I try to put a picture in your mind of when you think of estate, kind of think of a coin. And there's two sides of it. And one side is the side where acquisition, where you acquire it. And the other side is deposition, when you go ahead and you dispose of that ownership somehow. So how you title it when you own it is going to say how you can go ahead and sell it and pass it on someday. So for example, some property you might own as a sole ownership. And if you're the only owner of that, then that's part of your estate. And the way that that passes is through your estate. So if it's going to pass through your estate, at the time it passes, you're going to reach your demise, you're going to be gone. You're not going to be able to sign off on the documents passing that deed to somebody else. You're going to leave behind a will. You're going to appoint an executor, and that executor now has the power to go ahead and sign that deed and pass it on to somebody else. So that's if you're a sole owner. But other ways of owning a property is, for example, joint tenancy with the right of survivorship. So up in like northeastern Pennsylvania, for example, I'll see this where a bunch of guys will get together and they'll buy a piece of property because they all want to go hunting or fishing on it. And then however they decide to own it, for some reason, a lot of them decide to own it as joint tenants with the right of survivorship. So say there's 5 of them. Eventually, one day, one of them passes on. What happens to his share? Well, it goes to the survivors. Now it's owned by 4 of them. Another one passes on. Now it's owned by 3 of them. Usually by the time I hear about it, we're down to 2 of them. And the one who's older is like, maybe we should retitle it and have it a different way. But it doesn't necessarily work that way. Eventually, the 4th one dies, and then the 5th one, the final owner, is the one who owns it. Now once again, it becomes sole ownership. And again, it will pass through that final survivor's will. But prior to that, basically the owners who pass first are leaving it to the surviving owners. Another way to own property is tenancy by the entirety. And that's usually the way spouses own property in the state of Pennsylvania by law. By law, if you're spouses and you own a piece of property, when one spouse passes, just by operation of law, you don't have to do a new deed or anything. The property automatically passes to the surviving spouse. Also, there's other benefits you get being a marital couple as far as if anybody tries to collect against that property or anything. So it's good to own it by spouses. But if you're not spouses, another way you can own it is tenancy in common. And when you have tenancy in common, the owner's share passes through their will or trust. It doesn't go to the survivor. So it's important if you know when you're going to buy a property with someone else who you're not married to, whether you're going to be a joint tenant with the right of survivorship, that your share automatically passes to the other, or it's going to be tenancy in common, where when you pass, your share in that property passes through your will. It doesn't automatically pass to the surviving person.
So once we kind of have titling done, then there's the documents that control the property. How should investors think about integrating LLC-owned properties into their estate plan when ownership interests vary across the projects?
So when you got several different projects and you got several different LLCs that own different properties with different people, you got to realize that you can't pass that property through your will or your estate. What you are passing through your will or your estate is your membership interest in the LLC, and the LLC owns the property. That's an important thing to realize. The other side of it is as a member of an LLC where there's multiple members and there's property ownership or ownership of any type of business, when one business owner dies, their rights to that LLC pass to their estate. And their estate, now upon that one of your partner's death, has to be paid off. And if they're a 1/3 partner or even a 50% partner, paying them off might actually force the business to have to liquidate itself in order to pay the estate. So you want to realize when you have a business, if you want that business to survive the death of a partner, you have to plan for that. Often a way to plan for that is with buy-sell agreements, where the LLC will go ahead and enter into a life insurance policy on its owners. And the amount of that life insurance policy will usually be about 50% or 1/3 the value of the LLC. The LLC will own the insurance policy. Upon one of the partners' death, the LLC then turns in the policy and it has the funds to pay off the estate. Those are things to think about when you own property through businesses and several different business entities.
Yeah, I see operating agreements without buy-sell language in it, and that always makes me cringe, because even if you don't have a life insurance policy, which obviously I'm an advocate for, you got to have language in there for what's going to be the triggering event, how's it going to be valued, how's it going to be funded, which could be an installment sale or life insurance.
So that's it. Usually when people set up their businesses for the first time, a lot of those forms, the operating agreements, are standard form operating agreements. And the standard form operating agreements that most attorneys are using do not have any buy-sell provisions in them at all, do not provide for anything in the event of the death of a partner. So I would say that almost anybody who's got a business, whether it's an LLC, a corporation, or a partnership, chances are that your business documents do not provide for what happens in the event of a partner's death. And that's something that is really important, because that event is inevitable. It is going to occur someday, and how that event's going to be dealt with is going to be extremely difficult if those provisions aren't in there. And those provisions that are put in there, there's all sorts of things you can do. I mean, you might find that the business is very important to you, and half of it going to your family isn't important to you, but the survival of that business is. You could put provisions in there that the business is going to be deemed to be worth just $1 million and nothing more ever. And at the time that your estate gets bought out, that's it. Your surviving spouse or surviving children only get $1 million, even if that business has become worth a lot more. It also works the other way around. Say, you're doing estate planning and your business is only worth a couple $100,000 because you just started it, but you want your estate to be worth more than that. Well, you can go ahead and fund the life insurance policies for $1 million or $2 million. Those policies are paid for by the business, and now all of a sudden your estate, on a relatively small business that you just started up, it's only worth a couple $100,000. If God forbid something happens to you, now that business is going to pay your surviving family $1 million or $2 million on a policy that company owns. So there's a lot of interesting things that you can do with estate planning with us to increase the value of your estate, or things you can go the other way to make sure that that business survives one of the partner's deaths early on, and not too much has to be paid out that's going to destroy that business.
Mm-hmm. And then just to speak to that for a second, the limits on that, so you have a $200,000 business and you want to buy a policy that's maybe worth more than that, you can't go 100 million on it because you have things called insurable interest. So the insurance company is going to need some insurable interest in there for you as on the buy-sell side, or you can even look at it on the key man side. So there's ways to underwrite for that, but those are integral parts of how you place life insurance when you're doing those types of cases.
Another good point too was sometimes life insurance isn't a viable option for some people. Some people might have health concerns or whatever, and the life insurance just becomes cost prohibitive and you can't do it. But there's other provisions you could put in a buy-sell agreement too, where you can make it that if the business has to be sold, it gets a 10-year period or a 5-year period to pay off the estate or some greater period of time. So there's all kinds of issues that are going to come up. Whatever issues come up, usually for the most part, most of them have been dealt with before. And there's usually some way it could be dealt with in an agreement between the partners in a buy-sell agreement.
Kind of the last point on buy-sell agreements, and we're going to talk about taxes, is the buy-sell agreement that gets placed when you start everything needs to be reviewed, like estate plans. Because you start the business, it's worth 200,000, you guys get up and running. 5 years down the road, if you've never revisited that, it may not be sufficient to actually handle what you need to handle if something were to happen in death, disability, or retirement of a partner. So make sure those are getting reviewed. Don't have to review them yourself. We got attorneys for that. But I've looked at them before where I look at the buy-sell provision and I said, all it says in here is it gives you language on how to approach the other partner if one of you wants to exit the business. There was nothing in there for death, disability, or retirement. So it was a huge liability. And the other point on that is you don't necessarily have to amend the operating agreement. You can put a buy-sell agreement alongside of that, correct? Or do you reference in the operating agreement? Or how do you handle that if you're kind of amending that point, either because you realize you didn't have one that was adequate or you need to update it?
So normally the buy-sell agreement isn't necessarily incorporated right into the operating agreement. It usually is a separate document. And so updating it is a lot easier than having to go ahead and update the entire operating agreement.
All right, let's talk about taxes. So obviously, yeah, go ahead.
So the insurance policy, they have the buy-sell, they set up a reciprocal insurance policy. Who's the beneficiary of that policy?
The LLC is usually the beneficiary, and then the LLC pays off the estate.
And so therefore it goes into the estate.
Correct.
The money.
Yeah. Now the important thing well, we could talk about buy-sells all night. We'll probably move on from that, but it is important though that it's handled differently when the business starts to get to a certain size and the individual estates of the owners get to a certain size where estate taxes are of interest, because the death benefit of the buy-sell agreement may increase the value of the business. We learned that through Connolly, recent case from this last year. So there's implications there where you want to own it maybe slightly different if there's that concern versus a regular cross purchase or something along those lines. So again, those aren't things that you have to like intimately know, but you should realize like, oh, these things need to be reviewed on a regular basis. I got to get eyes on this because you're running a business. There's a lot of other things to look at. So let's talk about taxes for a moment. Estate taxes, the exemptions, $15 million per individual starting next year, slightly less now. $30 million for a married couple, and then there's estate taxes. But what about below that? There's a lot of real estate investors that may not have a $30 million portfolio. How should they be thinking about step up in basis for inherited real estate? And how could gifting property during lifetime potentially backfire?
So when you inherit a property or you're gifted a property, there is some type of tax you're going to have to pay on it. Usually it's a realty transfer tax, and there's also capital gains tax. As far as capital gains tax goes, if you receive that property as a gift during a person's lifetime, then when you go to sell the property, the value of the property is the value that it was when they purchased it. So say that your parents purchased a house for $100,000 and they gift it to you now and it's worth $700,000. They gift it to you now, you got to pay the capital gains on that $600,000. If they don't gift it to you now, but they leave it to you as part of their estate, then that property, the value given to the property when you sell it is the property value on the date that the estate occurred and that you inherited the property. So the property is now worth $700,000, and you go ahead and sell it a year from now at $750,000. You're only paying capital gains on $50,000 instead of the difference between $100,000 and $750,000 from when they bought it. So it's that stepped up basis. So for capital gains purposes, you're usually better off receiving the property through the estate than you are having it gifted to you during your parents' lifetime.
So one reason people gift during their lifetime is because they're concerned about Medicaid lookbacks and those types of things. Is there other, because then it can be includable in that clawback in the future after they pass, is there other options beside waiting to death, getting the step up, but having it be included in their recovery for Medicaid for long-term care?
There's always going to be other options, but no matter what option you go with, there is what we call a clawback period. And there's what we call a 5-year clawback period. And so what that means is if you're an elder person and you own property, if you take that property out of your name for less than fair market value, and within a 5-year period from doing that, you go on Medicaid, Medicaid is going to claw that back into your name, and it's going to use that to reduce your Medicaid benefits. So whatever you do, if you start planning earlier on while you're healthy and you feel that you're going to stay really healthy for the next 5 years, you're in a good spot because that's the time to start planning. And there's all different things you could do with trust and life estates and stuff of that nature.
So, oh yeah, go ahead,
I'm sorry,
Jared. Yeah.
So you gave the example of the property value of 700,000, and they sell it a year after for 750. They pay the capital gains on the 50. What if when the parent dies, the children sell the property the day after the parent dies?
No capital gains tax because it's given that property at death. So the sooner you sell it, the less your capital gains tax are going to be after death. But the property increases in value, then you will be paying the capital gains. If it doesn't increase in value or it decreases in value, there's no capital gains.
Is there a grace period on that, or just based on the value of the property?
Based on the value of the property, there's no grace period.
So let's finally kind of talk about what happens when the next generation inherits real estate and the family dynamics begin. So in estate planning, there's always the mechanics of it, but then there's also like, how do we keep family harmony in there as you are settling out these things after a very hard event? Real estate's hard to divide. So what are some strategies to help prevent family disputes or liquidity crunches when multiple heirs are inheriting property?
So that's tough. So for example, if you take somebody who has maybe a house down the Jersey Shore, and it's the parents, that generation that owns the house, and they pass on, they have 3 children. Now they go ahead and leave the house to all 3 children. There's certain provisions you might want to put in there because all 3 children may not even want the house, and there's expensive maintenance, and 2 of them might be, willing to maintain it, but the third one might be saying, I don't even go to the Jersey Shore anymore. I moved down to Florida. I don't care about it. I'm tired of paying these maintenance fees. And the other 2 don't have the money to buy them out. So when the senior generation does that, they want to make plans. They want to make plans. What happens if one person wants to buy out? How does that occur? What happens if one person no longer wants it? Do they get to be bought out? They might even want to consider not leaving it to all 3 children. They might want to consider leaving it to one child and leaving something else to the other children. They should have some appreciation of whether or not the children over the long term are going to want to do that. When you're doing estate planning, one of the things that you want to do is you want to give the problems and the anger to yourself. You don't want to leave them for the next generation. So even if you feel that you have a child that lives in Pennsylvania and the other 2 children live out on the West Coast and you're leaving this Jersey Shore property, you might want to say, I want to leave this to the person who lives in Pennsylvania and the other 2 kids are going to get some money or something. You don't want to leave those arguments and those bitter feelings for the next generation. And you want it to be your decision. Whatever those decisions are, there's a bunch of decisions you could make in estate planning, but you want those to be your decisions. And if your children aren't happy with that decision, you don't want them to be mad at each other. You want them to be mad at you. You're gone. You're in the grave. Don't let it carry on to the next generation. There's lots of decisions you can make in there. You don't have to leave it to all 3 children equally. You don't have to have all 3 provide for the maintenance of it. You might want to have buyout provisions that they get to buy each other out at the time that the will is read. There's provisions you could put in there. But the biggest thing to remember is one of the reasons that elderly people come to do estate planning is they want to make those decisions and they don't want to leave those arguments for the next generation. That's one of the things that proper estate planning accomplishes.
Thank you. Yeah, that's where we want to wrap up tonight. So we kind of covered business owned, basis, estate planning to the next generation. We could talk about probably each of those for 20, 30 minutes on their own, but we wanted to hit some of the broad topics around estate planning with real estate. And I appreciate you coming and giving us some of that information.
Absolutely.
So,
I thank you for having me here.
Yeah, go ahead, Jared.
One more question.
Yeah.
Do you suggest putting each investment property in an individual LLC?
So strictly looking at it from a business attorney point of view, we kind of look at it as a basket. If you put all your eggs in one basket, you drop the basket, they break. So if you have 2 or 3 different properties and they're all in the same LLC, and one of those properties, somebody's walking on the property and they get injured, and they get severely injured, maybe even die, now they're going to go ahead and sue. And whatever's in that LLC is subject to any judgment against it. So that's why we usually recommend putting those eggs in a different basket. And those different baskets are different LLCs, those eggs being pieces of property. So yes, the normal recommendation is there might be some reasons why those properties are unique and maybe they belong in the same LLC, but that would be some unique situation. But the general rule of thumb is each property should be in its own LLC for its own protection. So the LLC itself, the reason why you set the LLC up is because that's a separate entity from yourself and it protects your personal assets. And now when there's more assets to be given, you want to protect them from each other, just like you were protecting the LLC from your personal assets.
Thank you. Follow up to that. And if you have properties, investment properties in an individual's name, converting those over to an LLC, you have to pay transfer tax in order to do that.
So that's something that when you're initially doing it, if you have a good attorney and a good title guy, they will tell you right from the time of the agreement of sale, you want it to be an agreement of sale that it's under an LLC, or that it could be changed during the closing process to an LLC. You want to do that as early as possible, but it's correct. If you buy that investment property and title it in your own name, and then you want to retitle it into the LLC, you're going to have to pay those realty transfer taxes, and you want to avoid that.
Here in Pennsylvania.
Here in Pennsylvania,
It's
yes.
no different everywhere. Everyone
It
has
is.
to review that, right?
Here in Pennsylvania, but I know the one title guy in here that catches it every time. And that's why I highly recommend him every time. He catches it every single time, and make sure it's done right. And so yes.
Any other questions?
Just one more.
Yeah.
A lot of people when they get close to that time period of planning, their kids are kind of reluctant to take on the real estate. Do you recommend that they sell the real estate and put into a trust, or you just transfer the real estate over to the children? I'll let them figure that out.
So if you're talking about real estate that the children are going to have as their own residence, certainly that's fine to put it in their own name. If you're talking about investment real estate, then they certainly don't want to put that into their own name because they're taking on a lot of liability with that. They want to set up some sort of LLC or something. Now, if you have a senior generation member that has several different pieces of real estate and they're being run different ways, usually what we'd recommend is some sort of trust, and they're the trustee of that trust, and they're running it and they're overseeing it, the business aspects of it and everything. But in that trust, then they appoint somebody else to be a trustee to take their place upon their demise, maybe one of their children's. And that's an easy transfer because now you have somebody else stepping into the shoes of overseeing all those properties and the business purpose of those properties. So usually it's a good idea to have those properties both in LLCs and those LLCs in some sort of trust with some trustee overlooking the business purpose of those properties together.
So do you think is it better to have properties in a trust or an LLC? I'm assuming they give different types of protection. And the only reason I ask that, Jared, is because certain transfers from individuals into a trust are exempt from transfer tax, whereas into LLCs are not.
Got it.
So I'm just curious about titling in trusts or transferring to a trust or what they.
So it's going to depend on a lot of different things, but normally the rule of thumb is you're going to take the property and you're going to put it into an LLC to protect its own assets separately, and then those multiple LLCs, you might go ahead and then put into the trust, have the trust have membership interest in those LLCs in order to coordinate what's going on between the different LLCs.
Great.
All right, guys, thank you so much. Hope you guys enjoyed that. Make sure you guys scan the QR code so we can share all our information with everyone, okay?
Yeah, we'll send a video out later to everybody that registered, and appreciate you coming out. Kept you a little bit late.
Yeah,
It's dark out.
Yeah.
Yeah. Thanks.
Yeah,
We're
thank you.
planning, just so you know, we're planning to do another event in February probably. So you'll hear about that as we get closer.
Yeah. Thanks.
For Valentine's Day. Yeah.
We are being involved in the next meeting.